Welcome to Canadian Justice. I'm K.R. Davidson. Today we are talking about a recent decision of the Supreme Court of Canada relating to jury selection. In 2018, an all-white jury acquitted Gerald Stanley, a white Saskatchewan farmer, of killing Colton Bushy, a Cree man from the Red Pheasant First Nation. The case was highly controversial and shed a light on both racial tensions in the country and a legal rule relating to jury selection, known as peremptory challenges. Peremptory challenges is the ability to reject potential jurors without having to state a reason. In the Bushy case, the defense counsel used this rule to exclude Indigenous people from the jury. Shortly after this case, the government introduced Bill C-75, which abolished these challenges and was recently upheld by the Supreme Court of Canada. With me today to discuss the topic of jury selection, Bill C-75, and the recent Supreme Court case is Caitlin Casper, a lawyer with Aboriginal Legal Services, and Peter Thorning, who served as counsel for the Canadian Association of Black Lawyers at the Supreme Court of Canada case. Thank you very much for being with us today. Mr. Thorning, if you might be able to give our viewers just a little bit of an understanding of how does jury selection work in criminal cases, and then we'll go into certain questions about what a peremptory challenge is.
Jury selection in Canada can be, I think, easily divided up into two different concepts. There is the out-of-court jury selection that takes place when people are mailed out invitations to come to a court. And there's a process that is associated with that. And every province has what is called the Juries Act. And the Juries Act will lay out the terms upon which a person may be called to court, or other people may not be called to court. So that is the out-of-court procedure. There then is an in-court procedure that relates to, once you have all those people there in court, how do you pick your 12? And so there are a number of steps that are taken in court to reduce the number of people that are called to court to get your eventual 12. The peremptory challenge was one of those mechanisms by which you called down the number of people that were called to court as prospective jurors. So there's an out-of-court procedure, and then there's the in-court procedure. Peremptory challenge was one aspect of the in-court procedure.
So both Crown attorneys and defense counsel prior to this had the ability to exercise a peremptory challenge, which just means without any reason they could say that they didn't wish a prospective juror to serve in that case. What were some of the reasons why either defense counsel, I guess in your case you'll be able to speak to that, but you're a former Crown attorney as well, why would they exercise these challenges?
Well, I think a number of people have exercised peremptory challenges in a way that they thought might increase the representativeness of a jury. Or other people have exercised peremptory challenges to remove those people that didn't seem to pay attention to the process or want to be involved in the process, or people who they thought may unnecessarily conflict with other jurors in arriving at a true and impartial verdict. There have been criticisms of the use of peremptory challenges, which I'm sure we can get into, but the main purpose of the peremptory challenge when it was first came into being was that it gave the accused person some opportunity to be involved in the selection of the people who were going to be sitting on his or her case.
Interesting. So, Ms. Casper, can you give us a little bit of a factual understanding with respect to the Bushy case and some of the concerns that were highlighted and what the government had to respond to?
Absolutely. So In 2018, as you had mentioned, a Saskatchewan farmer, non-Indigenous, killed Colton Bushy, and there was a jury trial that was selected. And as part of that jury trial, it took place in the Battleford district of Saskatchewan, where there is an estimated 30% of the people in that district identify as being Indigenous people.
So, Ms. Casper,
when jury selection,
we're going to have to go to a commercial break just in a few seconds. So I'm just going to stop you there, and then we're going to pick up with your comments right after these messages. Welcome back to Canadian Justice. We're here with our panel of lawyers. We're talking about a concept called peremptory challenges that affects jury trials in Canada. So, Ms. Casper, before the break, you were highlighting some of the details of the Bushy case. If you can carry on to do so, that would be great.
So as I was saying, the Battleford Judicial District in Saskatchewan, where the jury pool was collected from, there is an estimated 30% of the individuals who are living there identify as being Indigenous. What ultimately ended up, and it was predicted beforehand that this would happen, ultimately it ended up that it was an all-white jury, and there was a conviction. There was no conviction, although it was open to the jury to have either convicted for second-degree murder or manslaughter. It ended up that there was no conviction at all. It was an acquittal. And that there was a lot of public concern and a lot of scrutiny as to how that had happened, given what the public knew about the facts of the case. And when that happened, there was a lot of analysis of the kind of recommendations and the reports that had come before the Bushy trial, in terms of how jury selection was done, in terms of how Indigenous people had or had not been represented in decades of the criminal justice process. And ultimately, the Liberal government made a decision through Bill C-75 to eliminate peremptory challenges entirely.
So I'm going to come back to you in a moment just to take a look at some of the background here, because I know that Justice Iacobucci did a report on Ontario, and then Marie Sinclair commissioned something in the Senate. But before we do that, Mr. Thorning, can you give us an understanding, because it seems like not only with Bill C-75, but there's been quite a bit of changes over the last 10 years on jury selection, which is probably not a normal process to have this many changes on a particular area within the judicial system. What has been sparking some of these changes, and what specifically occurred with Bill C-75?
Well, in my view, Bill C-75 was Parliament's response to the unfortunate circumstances of the Bushy case. And oftentimes, bad facts make for bad legal decisions. I think that there has been a fundamental sort of misunderstanding of how peremptory challenges are used. I think that there's been a fundamental misunderstanding as to what we can do in the case when a peremptory challenge is not used or thought to not be used appropriately. The jury trial gets a lot of attention in Canadian criminal law, because it is one of the only opportunities for the public to really have their say in the legal system. And so it does take on a great deal of importance.
And so, Ms. Casper, maybe give us an understanding of the background that Justice Iacobucci gave in his report, and Senator Sinclair gave, that sort of, I think, framed the decision that the government made on Bill C-75.
So we know, so you kind of have to start, I think, in the context of why these reports were done in the first place. So we're well aware in Canada, and the Supreme Court of Canada has made it very clear that there are deep roots of alienation and disconnect for Indigenous people in Canada when it comes to the criminal justice system. A part of that is that there are numerous barriers to justice. And so in 1991, for example, Justices Alvin Hamilton and Murray Sinclair authored the Manitoba Aboriginal Justice Inquiry, which talked about how the discriminatory use of peremptory challenges was a significant problem that needed to be addressed. And they talked about how defense counsel and Crown counsel both utilized peremptory challenges to exclude Indigenous jurors from being present on the panel. And that happens regardless of whether or not the victim or the accused in the criminal trial is Indigenous. In 2013, we had the First Nations representation on Ontario juries, Justice Yakabuchi, who also indicated that First Nations jury service was significantly undermined through the use of peremptory challenges.
It's very interesting how you frame that it's not only in the position where an Indigenous is an accused, but where they're a victim as well. Stay with us. We're going to continue on this topic when we come back after these messages. Welcome back to Canadian Justice. We're here with our panel of lawyers discussing the ban on peremptory challenges with respect to jury selection in Canada. Mr. Thorning, it's my understanding that in the submissions that you made before the Supreme Court, your client advanced that, in fact, peremptory challenges actually helped diversify juries and the selection thereof. Can you give us an understanding of what your arguments are that you advanced and how that might be the case?
Well, the argument was premised on the reality that Blacks are overrepresented in the criminal justice system across this country. And that is the unfortunate reality. And so as a result of that, many Juries Acts across the country prevent people who have had some involvement with the criminal justice system from sitting on juries. And so that typically when you come to court, you don't really see, when you come to court to select your jury, you don't really see a cross-representation of the number of ethnicities and backgrounds and diversities that we have in this country. Typically, you see white people who are property owners, who are people that you select jurors from. And so a peremptory challenge was used by many counsel to increase the diversity of a jury so that the charter guarantee of a representative jury could be met.
So, Ms. Casper, it's my understanding from some of the studies that precipitated Bill C-75, there's some indication that the peremptory challenges actually prohibited the diversity on juries and part of the jury selection. Can you expand for the viewers on what some of the studies revealed?
Absolutely. So in the Manitoba Justice Inquiry Report, they talked about how there were a number of cases where Indigenous people were the victims of violence. And that's the unfortunate reality, as my friend mentioned, in terms of that overrepresentedness. Indigenous people are overrepresented not only as being the victims of crime and victims of violent crime, but also individuals who are charged and who come through that criminal justice process as well. In terms of the studies that were done, they took a look at what was happening on the ground in the jury trials and in the jury selection process. And overwhelmingly, both Crown Counsel, Defense Counsel used their peremptory challenges to eliminate the Indigenous people who had come, who were willing and able to participate. And that was echoed in Justice Yakabuchi's 2013 report for the First Nations representation on Ontario juries. And I think one of the most important kind of quotes or lines that came from that report talked about how even if every change in that report was implemented to the fullest, First Nations jury service would still be significantly undermined through the discriminatory use of peremptory challenges. So even if every recommendation in that report was implemented, it would all be for naught as a result of peremptory challenges being used. And so I think that that's what we're taking home here in terms of their significance to Indigenous people and the real barrier they put to justice.
So, Mr. Thorning, basically, Bill C-75 came into effect. It was challenged thereafter, and we saw that it was upheld. What was the premise of the argument? Because basically, juries are enacted for the purpose of for the accused, the rights of the accused. In this place, what was the balancing that the court had to deal with respect to the rights of the accused versus the desire to have diversification on juries?
Well, let me just quibble a little bit. The jury is for the public as well as the accused. The fact that you have people coming in from the public to make a determination of guilt or innocence in a given case gives the system, gives the verdict some legitimacy. So the jury, the body, is for the public as well as the accused. I think the Supreme Court of Canada ultimately is concerned about the lack of control that is applied to the abuse of peremptory challenges. And that is the most, I think, significant issue for the Supreme Court of Canada. They didn't believe that there were sufficient safeguards in place to prevent an abusive use of the peremptory challenge.
Well, very interesting. When we come back, we're going to take a look at where the current law stands. We'll be back after these messages. Welcome back to Canadian Justice. We're here with our panel of lawyers, and we're talking about a concept called preemptory challenges in jury selection in Canada. So, Ms. Casper, Bill C-75, it's been upheld in the Supreme Court of Canada. Has this taken away the ability to challenge jurors? It's my understanding that there's a new provision that allows for the challenging, but one must justify their position in doing so. Can you expand on that?
Absolutely. So the whole idea behind peremptory challenges was that there did not require any kind of explanation to the court or to anyone else about why that individual was being chosen not to sit on the jury in the first place. So the problem with that that has been described is that peremptory challenges can be used through beliefs, racist, discriminatory beliefs about who a people are, about how they'll make a decision, about how they'll decide. And it's not actually based on any real evidence in terms of that juror having the ability to receive the information, the evidence they've received in court, and to make a decision, as my friend said, as part of the community, as part of the public, to make sure that justice is done. And so the elimination of the peremptory challenges now means that if a jury is called forward, if they are willing and able to sit, that if that individual, whether it be Crown or defense, decides that they don't want that individual sitting on the jury panel, they have to actually have reasons for it that need to be explained to the judge. And then ultimately, it's going to be the justice who will make that decision about whether or not there is those grounds to have that juror removed. And so that's the big fundamental difference.
So, Mr. Thorning, can you give us an understanding now that we have a provision that allows for the challenging of jurors based on a justified position? What are some of the reasons that can be advanced by the Crown or the defense to challenge someone that might be justified?
So Section 638 of the Criminal Code remains, and Section 638 is a challenge for cause procedure, which would require counsel to demonstrate that for some reason the juror cannot be indifferent as between the Queen and the accused. And typically some of the reasons that are used are pretrial publicity, exposure to pretrial publicity, or having an attitude, having the type of negative attitude that would prevent you from making a decision based only on the evidence and the instructions from the court. There's a new Section 633 of the Criminal Code that most importantly would be applied by the justice after a challenge for cause. And if counsel can demonstrate, or if the potential juror raises an issue with respect to their personal hardship, or what is called maintaining public confidence in the administration of justice, if there's some basis upon which you believe, and it would appear to be based on some evidence, that you have some reason to expect that the person cannot render a decision in accordance with the instructions in the law, then the judge is empowered to remove that person from the jury panel. But there has to be a reason.
Okay. Ms. Casper, we just have 15 seconds left, but do you believe that C-75 advances what was put forward by Justice Bushy and Senator Sinclair?
Absolutely. But I think my friend will agree that there's a lot of work to be done on the justice system in terms of supporting juries, educating juries, and making sure that they're able to participate fully. And so I'm looking forward to the next step in terms of how we're going to do that.
Thank you both for coming on our show today. Today we discussed attempts to remove discriminatory practices from Canada's jury selection process. Those arguing in favor of the ban on peremptory challenges applauded the move to remove a tool used to advance discrimination, and more specifically, a tool that was used to exclude Indigenous people from serving on juries in Canada. On the other hand, defense lawyers argued that peremptory challenges actually serve as an important tool for accused persons and aid in promoting jury diversity. In addition, they've argued that more work needs to be done to ensure that jury selection advances what is best for the public, specifically for advancing representation. Chief Dan George stated, "The heart never knows the color of the skin." So what do you think? Is Bill C-75 the most effective way to eliminate discrimination in Canada's jury selection process? Or did it remove a tool that was used to encourage diversity on Canadian juries? You be the judge. I'm K.R. Davidson. Thanks for watching Canadian Justice. Keep examining and know that you are part of the solution.